Good morning. I say this hearing room is a little bit more difficult to get used to than the one over in our normal hearing room in the Agriculture Committee, but we thought we would do this in honor of our former colleague, Senator Eagleton, being here, and also because we found that we didn't have enough seats in the other place. I'll be very brief in my opening statement because we have a number of things to cover. Senator Lugar will be here. He is at another matter that he cannot get out of, and he will be here about 10. During this past year, regulation of the futures industry has lurched from crises to crises. We've seen a sting operation exposing widespread fraud in the trading pits, a CFTC report criticizing audit trading systems, and a soybean emergency exploding in July. The system has simply not worked. Rules have been ignored. Customers have not been protected. And without the public's trust, futures markets cannot function. They cannot serve the needs of our country. This unique American institution stands in serious danger of being changed unalterably and for the worse. And we cannot and will not tolerate abuses of the system. Criminals will be punished. Weak laws will be strengthened. Law enforcement officials will be given the tools to crack down. Now, S-1729, the bill introduced by myself, Senator Lugar, and Senator Kerry, is a tough bill. It demands tough solutions for tough times. It's time to bite the bullet and fix the problems. And with Senators Lugar and Kerry, I plan to move this bill on a fast track. We introduced it 2 weeks ago. We plan to move it through the Senate this year. Today we're here to discuss S-1729 to hear the testimony of witnesses. We cannot finish the CFTC reauthorization without examining last Friday's stock market plunge. And for these reasons, I've sent CFTC Chairman Wendy Graham a letter asking her to analyze last Friday's events, paying particular attention to the cooperation of federal and exchange officials, reforms instituted after the 1987 crash, and the financial integrity of the market. And the report from the chairman, of course, will be of great help to this committee. Senator Kerry?
Well, Mr. Chairman, just very quickly, support your opening statement and indicate that the difficulty that I'm having in considering not only the changes proposed in 1729, but also in the whole question of reauthorization, is that, as Senator Lugar, I think, stated it very well, there's been a collapse of confidence in the whole scheme of self-regulation. That is as a consequence of a retreat in position over the past 9 months. A retreat that began with strong statements that said that the Sanders case was an aberration, that the incidences of that particular case and the comments made by the judge was inappropriate, that everything was pretty well under control, that we shouldn't worry about these investigations that were going on, that we've been fully apprised of the situation. Then all of a sudden the indictments come down. The Ferruzzi deal follows shortly after that. And the confidence that we had is dissipated, I think, as a consequence of this entire series of events. We're at a point now, at least I am, where I'm beginning to call into question many of the basic underlying premises that I had previously accepted as an article of faith. And I appreciate, Mr. Chairman, you and Senator Lugar preparing S-1729 and permitting me to come on as a co-sponsor, and I appreciate your effort throughout the year in directing our attention to this very important matter.
Thank you very much, Senator Kerry. And our first witness is Senator Thomas Eagleton. And I might say, just as a personal statement, one of the, when I look back at what I have found most rewarding of my own experience of being in the U.S. Senate is serving with Tom Eagleton. We served on different committees together. Most recently, of course, the Senate Intelligence Committee. I found Senator Eagleton to be a senator who asks the right questions and keeps on asking them until he gets the answers. He's also a senator who took his job seriously here, and was one of those who, when he left, when we all went onto the floor to make our usual statements of goodbye, this was a case where the expressions of regret that he was leaving were actually honestly made by senators on both sides of the aisle. Senator Eagleton.
Thank you, Mr. Chairman, and I appreciate your invitation to be here today and testify on S-1729 and related matters. After leaving the Senate, I became a member of the Board of Governors of the Chicago Mercantile Exchange, and I still am a member of that board. Insofar as the prevention of misconduct is concerned, the Futures Exchanges of America operate on three long-standing, interrelated tenets, or articles of faith, as Senator Kerry would put it. All of these tenets, all three of them, I'm sad to say, are false. Tenet number one, self-regulation. It is deemed to be the be-all and the end-all in assuring the integrity of the futures exchanges. Mr. Chairman, the futures industry deals in billions and billions of dollars and in millions and millions of transactions. In terms of its fiduciary relationship to the public, it is akin to a bank or to a savings and loan. No one would espouse, especially today, that the banking or the S&L industry be collectively self-regulated. No one can expect any industry at all times to put the public interest ahead of its pocketbook interest. Greed and temptation are still words in the dictionary. False tenet number two, benign governmental supervision. Well, here's how this one plays in the futures world. If the folks won't buy our self-regulation pitch, let's make sure that whatever the federal government does falls somewhere between benign and timid. Fulfilling this prophecy, we have the Commodity Futures Trading Commission, just about as benign and timid as they come. Somehow Congress designed it to be timid and has kept it timid by inadequate funding and a 3-year reauthorization cycle which keeps the agency in perpetual fear for its own existence. At one of the mercantile hearings we held in New York, a former member of the Commodities Future Trading Commission said that when he was on the commission, the last year of the 3-year cycle was spent devoted entirely to trying to get reauthorized. That's all that was on anybody's mind. We got to get reauthorized. Spend the whole year worrying about that and fooling around with that. That's how it was. I suspect that's how it is. Perhaps 90 to 95% of the CFTC's professional staff time is tied up with processing routine, albeit necessary work, but routine. Only 5, maybe 10% of its time, maybe as few as 25 to 35 professional people are available to respond to various major policy needs. When something like a Feruzi soybean matter breaks, the CFTC is overwhelmed. Indeed, it approaches paralysis. It cannot respond to other needs. And as demonstrated by the FBI Chicago sting, the CFTC throughout its entire existence has been mostly too little and mostly too late. Mr. Chairman, if the CFTC is to remain as a separate independent agency, it should have full authority to monitor and investigate the futures industry on an active, ongoing basis. Your Senate bill moves significantly in that direction. It should have the power to conduct undercover operations and the financial wherewithal to conduct these in the pits where the big action is in play. During the sting operation, the limited number of FBI agents with small play money were playing in the small pits. And yet, I don't know how many indictments came out of that. But the big pits, where the big money is and the big action is, were uncovered. Why? Not enough agents, not enough play money. So undercover operations in the future need people and the money to play where the action is. And then you'll get some results. It's absolutely imperative. On the other hand, if the CFTC is always to be treated as a regulatory stepchild, then I think it should be folded into the SEC. This remedy, this SEC remedy, is no panacea, but it is certainly better than today's status quo. False tenet number 3. Too much regulation in the name of integrity will bog down the markets and will dampen market liquidity. There's a rather likable old future guy in New York who loves to say, "Okay, you want honest markets, do you? I'll tell you how to have honest markets. Shut them down." To put a reverse spin on this enlightened commentary, this likable old pro is saying, quote, "If you want active and liquid futures markets, they have to be crooked." Hogwash, or some other similar word. In the era of super technology, you can have fully liquid and fully active markets and still offer responsible monitoring and enforcement of the law. Crookedness need not be the indispensable grease of America's futures markets. The futures exchanges with their open outcry systems invite illegalities, self-dealing, and customer abuse. Open outcry may have served a purpose in the era of the quill pen and Ebenezer Scrooge, but it serves absolutely no purpose in the age of Globex, invented by the Chicago Mercantile Exchange and adopted by the Chicago Board of Trade. It's a 24-hour automated international trading system. How is it? How is it that electronic trading can be a historic breakthrough 24 hours around the clock in Singapore and Hong Kong, but it's a dreaded evil in Chicago and New York? Fully electronic trades leave an audit trail that can be verified. And if there are 2 words that ought to be the motto of these hearings, those 2 words are audit trail. Simply put, open outcry in pits of hundreds of shouters, winkers, gesticulators, and body touchers cannot be adequately verified and monitored. The provision of the Senate bill which deals with, quote, the next generation of audit trail technology addresses this issue just so long as open outcry doesn't somehow remain as part of the next generation. I have one other thing to add. The CFTC should be mandated to establish minimal educational and training standards and monitor the training, education, and continuing education courses of both new, incoming, and old traders and brokers. Mr. Chairman, a cosmetologist receives more training for his or her trade than do the traders and brokers of our nation's futures exchanges. No doubt about that. More time is spent in training for cosmetology than in training to be a trader. As one veteran Merck trader has stated, one of the most respected senior traders, we've got a lot of people out there that shouldn't be out there, meaning out there is on the floor of the exchange. There are a lot of them out there. Roosevelt said something about ill-housed, ill-fed, ill-clothed. Well, I'll say there's some out there in those exchanges that are ill-trained and ill-motivated. And they ought to be found out and eliminated in the nicest sense of that word. Thank you, Mr. Chairman.
Senator Eagleton, no one can say that you sugar-coated the testimony today, and I've discussed this with you before, and you have corresponded with the committee before, and I find your testimony extremely important. Might also say that in many ways the Chicago Merc deserves a lot of credit putting you on the board, because I suspect you've been anything but cozy coming over there. And I give them credit for not only having you there but as a public director, but making sure they had a public director who's willing to speak out. And with that, do you feel that there are enough public directors on the governing boards of the futures exchanges? Are the governing boards themselves diverse enough so that the public interest actually gets heard? It's obvious in your testimony here that you are not being given a party line and said, this is what you got to say, here's where you go. I don't think there's anybody there, the Chicago markets that gave you your testimony said, go ahead and say this. You stated something entirely different than what we normally hear or ever have heard, at least in the 15 years I've been here on CFTC reauthorization. So are there enough public directors? Is there enough diversity?
No, there's not enough diversity. The boardroom's about as big as this, or maybe as big as Candlestick Park. And in terms of public directors, there's me and Susan Phillips, who used to be on the Commodity Futures Trading Commission, and she's a vice chancellor, vice president of the University of Iowa. Then there are 3 or 4 people who are in New York involved in the futures industry and use the exchange. They don't come out to Chicago. They're sort of affiliated members. I don't think really they're public members. And then everybody else is in-house. So in terms of outside, unconnected public members, they're 2 out of 25 or 30. It's a big room. Lots of people. Not enough.
The extent you see weaknesses in regulation of the futures trading pits is the problem primarily at the exchanges or primarily at the CFTC, or where would you allocate the problems?
Well, my testimony puts it on sort of an even balance. The CFTC is emasculated, as I say, timid, and only responds when calamity occurs. Whether it's the soybean calamity or silver or potatoes or what have you, then the CFTC perks up. Other than that, it's Sleeping Beauty. Now, as far as the exchanges are concerned, they go through this notion of self-regulation. They really believe in it, a lot of them do. They're really regulating themselves. They really think they're exercising a lot of oversight over themselves. And it isn't working. As Senator Kerry pointed out, the sting operation alone shows that it's not working.
You don't think that they're doing enough to crack down on abuses in their own trading? Are they making an effort at it? I mean, are they making a good faith effort and limited by personnel, or are they just ignoring it? How do you see it?
No, it's not a total ignoring of it. They have what's called a compliance division. They have a former SEC enforcement type person who heads it up, and they poke around a little bit on the floor, but they're very timid themselves. They don't want to take on powerful people on the floor. It's self-regulation in this kind of an industry is simply not attainable. They're going through the emotions. They think they're going through them zealously, but the end results are not there.
You just said earlier that on the problems of the CFTC, the reauthorization, it's short term. What would you do? Would you give it a permanent, in effect, yes. It does have a permanent authorization. The reauthorization is kind of a hybrid sort of thing, but would you make it a 5-year, 10-year?
No, I'd make it permanent. I would make it no less impermanent than any other regulatory agency. The reason for the original reauthorization concept was, well, this is a brand new thing. We're just starting this out. We're going into these markets. Let's see how it does or doesn't do. Well, it hasn't done very well, but one of the reasons it hasn't done very well is this overhang over its existence. They get very worried down there about what Congress is going to get all excited about and what the exchanges are going to get all excited about. It's one of the few regulatory agencies that I know that's very much fearful of those people whom they're regulating. They're getting all in a tizzy about the people they're regulating. And all in a tizzy, what's Congress going to do to us in our budget and what have you. And if they were given permanent status, then this anxiety that pervades the commission might go away.
Do they also get service fees of some sort from that same industry that benefits directly from their activities?
Yeah, absolutely. I think the budget of the CFTC is going to have to go up, and part of the up ought to be service fees. There's plenty of money out there to pay it. I find nobody on Wacker or the other streets to be impoverished. No homeless in those buildings.
May I ask one last question? If the major exchanges want to, could they implement the new computerized audit trail technologies? We talk about in this bill, we use the GAO 3-year timetable. Do you see any reason why that couldn't be done within that 3-year timetable?
I don't have the background to ordain what the precise year period ought to be. The GAO period seems good enough to me, but I know this. That the technology will be there. Do not buy the notion that they'll never be able to achieve it technologically. Because when they leave Chicago, they brag about the technology that they invented. For every other city in the world, as I mentioned, Hong Kong and Singapore and everything else. And if they can do it there, they can certainly do it in Chicago. I'll pass on whether it's 3 years or 2.5 or 3.5. I'll leave that up to you and the GAO.
So we can keep the Missouri bond going here. I'm sorry, that was a terrible pun. I will yield to Senator Bond from Missouri.
Thank you, Mr. Chairman, and it is a pleasure to be with you today to discuss the bill with a wide range of experts, and I'm particularly pleased to see my predecessor and good friend Tom Eagleton. Senator, I'm glad you have some views on this. With a good deal of enthusiasm, you've put forth your ideas on what needs to be done. I've had the pleasure, Mr. Chairman, discussing this with Senator Eagleton previously, and we certainly appreciate his testimony today. You know, 1989 has been a very eventful year for our nation's futures exchanges. We began with the indictment of 46 traders in Chicago, and then there was the summer soybean crisis and last Friday's plunge in the stock market, which had an impact on all the markets and also focused new attention on Chicago and the other exchanges. We are very concerned that farmers, processors, small investors continue to have legitimate concerns that adequate safeguards be in place to prevent actions or activities that would be harmful to their livelihood. I think the reauthorization bill gives us an excellent opportunity to implement changes where needed to increase oversight, ensure accountability. I think we also must be careful not to regulate some market participants out of business. We have to take note in our actions, as the CFTC must take in account in its actions, of the special circumstances of smaller exchanges, some of which account for fewer than 1% of the contracts traded in a given year, yet they play a key role in the contract market. In our zeal to impose the highest standards on the larger exchanges, I think we have to take account of what special circumstances there may be in some of the smaller exchanges and not require them to achieve advances that are beyond their capabilities. I know that we have much good information to hear today. I would only ask Senator Eagleton a couple of questions. I apologize, Tom, that I missed the first part of your testimony, and you may have touched on it then, but Friday and yesterday we had the first opportunity to witness the action of the reforms brought about as a result of the 1987 problem. It's clear that this was not a panic on the scale of Black Monday of 1987, yet we did have a few people nervous. Some of the circuit breakers clicked in, and we don't yet know how this week will play out. But based on what you've seen to date, do you feel that the reforms that came about as a result of the 87 crash are working? Did they make a positive contribution? How do you assess the actions of Friday and yesterday?
Senator, I think the jury is still out on that issue. Yes, some of the circuit breakers did click in on Friday. And yes, Monday was down, not down 508 points, as was true on October 19th, 1987. I think you have to give credit for yesterday to the Federal Reserve System, in my opinion, and to the weekend. Thank God for the weekend. If it had been successive days, it might not have been as good. But the weekend, 2 days intervened. And Mr. Greenspan, to his credit, came into action. And if there's a savior for yesterday, it's Mr. Greenspan, and I don't usually say such nice things about him.
I'll make a note of that,
Yeah.
Alan. Appreciate that.
Call Alan right after the meeting.
Yes, we'll get through to it. But there was a weekend between October 16th
Yes,
and October 19th, and the Federal Reserve played a very important role. Some would say the Federal Reserve is the only thing that saved us from disaster in 1987 as well.
Yeah, but they didn't swing into action until Tuesday, the 20th. There was 100 points down on Friday, then the weekend, then the 508 on Monday. Then Mr. Greenspan, who was giving a speech in Texas, swung into action on Tuesday. This time it was a little more advanced, and I think thus more helpful.
All right. One of the things that you suggested is the limited nature of the board makeup. If you've had a chance to look at the draft bill, do you have any comments about what is mandated on terms of board makeup, or what about the makeup of the disciplinary boards? Do you think that we in Congress ought to mandate who should be represented? Should that decision be made at the CFTC level?
I suspect if you leave it to be made by the CFTC, it won't be made. So, although under normal circumstances, I would perhaps leave that to the CFTC, not under these circumstances with the past track record of this agency, who is famous for its inability not to decide. So, I think you have to legislate a minimum of X percent, what's the bill say, 20, 25% of public members. And then you have to legislate a minimum insofar as who serves on the disciplinary committees. And I would, because as you recall, Senator, when you were governor of Missouri, I helped create a thing called the Independent Hearing Examiner. I think all of the hearings for discipline before all of these boards ought to be held by independent hearing examiners. They'll tell you, oh my God, only us insiders understand all this terminology and all the complexities, and we're the only ones who really know. Meaning that the whole judicial system of this country is cockeyed, the judges don't know, and that senators don't know who have to make judgments about space and nuclear weaponry. Only they know. That's crazy. So I'd have an independent hearing examiner hold hearings on serious disciplinary violations. By meaning serious, those that could result
pygmy in comparison to the SEC. Do you think the changes contained in this bill address those concerns? Do you have other, do you feel that more drastic remedies such as you have hinted at in the past would be required?
Well, I'd pretty much settle for the bill as written. I know that some of my exuberance maybe can't carry the day. I'd pretty much settle for the bill as written, but what you see you cannot guarantee is the zeal of the CFTC to enforce. You can give them a new law. You can give them new authority. You can even enhance the staff a little. But if the policy of the CFTC is to sit back and watch the passing parade, then we're not all that much better off. So it's the motivation, the intent, and the will to enforce of the CFTC that is just as important as any bill that you pass.
Tom, thank you very much for your testimony. I have a feeling our next witness may show some of that zeal and some of that enthusiasm. So, Mr. Chairman, I thank you for the opportunity to participate.
Thank you very much. And we have Senator Kerry, Senator Conrad, and Senator Daschle in that order. Senator Kerry?
Senator Eagleson, before I ask you some questions, I'd like to actually direct your attention to something you don't talk about much in your testimony, and that is the CFTC itself, the board, and the makeup of the board, assuming for the moment, as I intend to in my question, that we pursue a permanent authorization. Let's assume that we have permanent authorization as the requirement. I would say as preliminary that I subscribe to a standard that says that whoever is in charge of the operation bears the responsibility for whatever occurs in that operation, though it may be unfair and it may be at times difficult to bear up under that responsibility. If I have control of a ship at sea, for example, and I ignore warnings of a ship ahead and wait till I'm an extremist and we are collided upon and lives are lost, I don't blame the rules of the road. I don't blame the Navy regulations. I don't blame my subordinates. I don't blame or I can, if I want to, blame all those things, but I'm not going to get very far. And in today's environment, unfortunately, we all too often, it seems to me, permit people who are in charge to shift the responsibility someplace else and say, well, if the rules had just been different, if I just had more money, had things been different, this would never have happened. It's not my fault, in short. I subscribe to the belief that we ought to, if you accept the responsibility of having the authority of a position with responsibility, then you have to, therefore, assume that whatever befalls you, good or bad, is yours. Having said that, as an underlying premise for my statement, I'd like to direct your attention again, assuming for the moment that permanent reauthorization occurs, that we authorize the CFTC permanently as we do the SEC. What would you do with the board? What kinds of requirements would you put for appointment, for example, to either the chair or for individual commissioner members? Would you expand it beyond 5? Would you look to specifically say in statute that there must be some experience with the market, that you've got to have some understanding of the thing that you're regulating? Would you adopt any other kinds of guidelines as you created that new board?
Well, you asked me what I would do. The first thing I would do after he's defeated for merit, appoint Ralph Giuliani as chairman of the CFTC. I'd appoint somebody vigorous that wants to pursue the investigatory aspects of that agency. And I guess he would pass a test as having experience in markets because of his prosecutorial experience at the U.S. Attorney's Office in New York. So I don't know what standards you could write in. And I don't know how you can write in motive, Senator Kerry. I was here during the demise of the Legal Services Corporation, where we knew the people that were appointed to that corporation didn't believe in it and wanted to destroy it. I was here during the time that Ann Gorsuch Burford was appointed head of the EPA, Environmental Protection Agency, and we knew that she wanted to destroy the very agency that she headed, etc. So I don't know how you x-ray the head of the appointees and say, is this individual really going to function vigorously, or is this person going to function in a laconic fashion? And you can write all the requirements you want, and you still cannot write in motive.
What would you look to do, though, if you were trying to, because it seems to me it's a critical component if you're going to have permanent authorization for the CFTC, some degree of confidence that the Commission is going to carry out the mandate of regulation.
Yeah.
And by the way, it's a fairly substantial requirement if you're going to give them more money. I mean, one of the things that's occurring in America today is that we're requiring increased accountability before we bring additional money, increased performance before we bring additional money, whether it's schools or prisons or law enforcement effort. That seems to be a new requirement. I don't think an unreasonable one in regards to CFTC either.
Well, I would be loath to write in that too heavily on the previous experience with the exchanges, because you might end up with only foxes on the exchange. You might end up that the only people who are applying for the jobs and qualified are out of the very exchanges that need the supervision. What's wrong with a retired federal judge being appointed to it, hypothetically, or a state judge, like Benjamin Hooks was a distinguished state judge down in Tennessee and was appointed to the FCC. Benjamin Hooks wasn't in the radio business or the television business, but he became a very distinguished commissioner. So I would be a little reluctant to write in super experience qualifications, finding that very intelligent, vigorous laypersons with good common sense were thereby precluded from consideration on the board.
What sort of things would you consider if you were making the appointment?
If I were making the appointment? Well, I would want to be very satisfied, were I the president or such other person that was doing the examination for him, that the individual and individuals being appointed to the agency, number one, believed in the kind of work that was being done, believed in the need to pursue their duties with full vigor. And just as I'm sure that a president should have done that, President Reagan should have done that, and the agencies I previously mentioned. Quite self-evidently, he went out of his way to appoint people who didn't believe in the agencies for which they had been appointed. So you can, by checking someone's background, by talking to people, by talking to the individual, you can find a bit out about the individual, about how vigorously that individual is going to pursue his or her duties. But I don't think I can write all this into statute.
Thank you.
Senator Conrad.
Thank you, Mr. Chairman, and welcome, Senator Eagleton. In reviewing your testimony, I noticed that your third point was too much regulation in the name of integrity will bog down the markets and will dampen market liquidity. And in that same section of your testimony, you indicated that, simply put, open outcry cannot be adequately verified and monitored. Now, in discussions with people representing the markets, they assert over and over that open outcry is very important to the efficiency of the market at this point, that they do not have the technology to eliminate open outcry and go to a fully electronic system, and that if they were compelled to, that perhaps we'd lose these markets overseas, to Japan, to Hong Kong, wherever. I'd just be interested in your assessment of where we are with respect to that basic conflict between efficiency and markets that operate competitively and an open outcry system that many would see seems to be an anachronism. What would be your analysis of the tension between those 2 points of view?
First of all, that item 3, that's not my argument, that's the argument of the industry. Let's make that clear. Number 2, I think the Leahy bill gives 3 years to move to this new generation of technology. Let me analogize another experience of mine here in the Senate. When with Senator Howard Baker and I and others were working on the first Clean Air Act and Clean Water Acts in the early 70s, the argument we heard was, we can't afford clean air and clean water because we do not have technology, and if you force technology upon us, we'll all go out of business, and what good is that? That was the argument, prevalent argument. You are forcing us to do things that are not technologically possible. When we set up the benchmarks of compliance, once we put them into law, then suddenly technology burst forth. Suddenly. New technology came out, and by God, what happened? They could achieve the requirements. Same with the automobile COLA standards, automobile gasoline standards. Ford and General Motors said we can never get to 27.5 miles per gallon. Never. I'm from a car state, as Senator Bond knows, second largest car production state. They all came in, never could achieve it, ever. Once we set it into law, all of them but one achieved it. Ford, I think. GM achieved it, little old Chrysler achieved it. So you pass a law that says open outcry is out in 3 years. I think that's what your bill is intending to say, and that a fully electronic trading system is in 3 years. It'll be in 3 years. Don't worry about it. You know, if it's in everywhere else in the world, it'll be in Chicago and New York in 3 years. Don't worry about it. But they'll tell you they can't do it before the 22nd century. They'll foot drag it to death. Don't worry, kid you about that. 3 years is plenty.
Let me ask another question that when I've been home doing community forums, you can imagine this set of events has disturbed many people in my state. And I remember very clearly being at a community forum and a gentleman standing up in the audience and saying to me, Senator, you know, I've been reading about this dual trading system where people on the exchange can trade for their account as well as their customer's account. And the gentleman said to me, look, he said, human nature being what it is, I doubt very much that somebody is not going to screw me when they're trading for their account and my account. At some point, I'm going to get cheated. I don't see a reference to dual trading in any great degree in your statement. I'm interested in your reaction as to how we ought to treat that.
You're correct, there is no reference at all to dual trading in my statement. I couldn't cover the waterfront, so I was selective. I'm less draconian on dual trading than I am on all of the other items previously stated. There are circumstances in little tiny markets where the trading is light, where dual trading is unavoidable. That's my belief. In the big S&P markets and all that kind of stuff, no dual trading. And thus, the exchanges and the Congress and the CFTC have to devise a formula that spells out the difference between liquid and illiquid markets in the context only of dual trading. There is some necessity for dual trading in the tiny markets. I would agree.
Well, let me just conclude by asking, in visiting with people who represent the markets, one of the assertions they make is, look, dual trading with a tightened audit trail is going to be very easy to pick up. If we have a clear record of the transactions, we're going to be able to pick that up. In fact, I had a major customer come and see me yesterday, and he said, look, dual trading is frankly, I don't think the problem. I depend on those markets, and the people we've decided to have trade for us are the dual traders because they've got a better feel for the market. What would be your reaction to that?
Yeah, some customers do seek out certain brokers and traders that are dual traders knowingly because they're good and they trust them, et cetera, and seek them out because of their knowledge of the market. And the problems over dual trading will fade away to a large degree 3 years from now or whenever it is that you have this fully electronic market. That gives you the audit trail. As I said earlier, I think perhaps before you came, Senator, the name of the game, in my opinion, as far as these hearings are concerned, is audit trail.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Conrad. Senator Daschle.
Mr. Chairman, we have a lot of witnesses. I'd just add to those who have already welcomed Senator Eagleton. He has enlightened us and certainly given us a good deal of food for thought, and thank him for doing so.
Thank you very much, Senator.
Just about the time you get your jacket off, Tom, we're going to say this is it. I thank you. I thank you very, very much for being here, and I thank you for the help you have given us. It's good to see you again. Before we call our next witness, who is the chair of the Commodity Futures Trading Commission, Wendy Graham, before we call her, I see our two distinguished colleagues, Senator Dixon and Senator Simon, here. I know they both asked to make a statement. I also know they're both supposed to be in other committee meetings, and so if there's no objection, why don't we, so they can get back to their other meetings, I invite Alan, if you and Paul come forward, and you both had something to say, and feel free to say it, and I appreciate you taking the time to be here because I know you both have tremendous schedules.
Thank you very much, Mr. Chairman and members of the committee. I appreciate, on behalf of my colleague Paul Simon and this senator, the opportunity to appear before you today as you look at the reauthorization of the CFTC. It's our privilege to introduce to you a number of witnesses that you'll hear today that are personal friends of ours. Karsten Malman, Chairman of the Board of Directors of the Chicago Board of Trade. Leo Melamed, Special Counsel and Chairman of the Executive Committee of the Chicago Mercantile Exchange. Robert Wilmuth, President of the National Futures Association. Barry Lynn, Chairman of Lynn Waldcock and Company. And Donald McElmurray, Chairman of the Commodity Exchange Committee of the National Grain and Feed Association. Mr. Chairman, I have a very brief statement that I ask your leave to place in the record of this hearing, and may I very briefly say this to my colleagues and friends on this committee. I would like to make 2 points. The first is that the futures industry is tremendously important to the economic viability of the city of Chicago and our great state of Illinois. I hope every member of this committee understands that the futures industry in our state employs over 100,000 people, places in the financial institutions of our great state every night $4 billion, and has imparted a tremendous economic vitality to our state. The second point I would like to make is that though I do not now serve on the Agriculture Committee. I had the privilege of serving there before. I hope some of you know that. I have served since coming to the Senate on the Banking, Housing, and Urban Affairs Committee. After the stock market crash, a good deal of legislation was considered in that committee. Mr. Nick Brady appeared at that time, along with a good many others, suggesting a variety of legislative responses to the stock market crash on that occasion. We urged at that time our colleagues to not go forward with the idea then to set up some kind of a super federal bureaucracy to overview everything that takes place in the futures industry. And we suggested that many of the things that were contemplated at that time were too harsh, and that if the CFTC and the market were able to work together, they could solve most of these problems with our oversight competence as members of that committee, along with the members of the Agriculture Committee. That plan finally went forth, and I would argue that this recent experience that we have had in the marketplace demonstrates that most of the corrections that are necessary have been made. Finally, I'd want to suggest that that everybody, including those that lead that industry, deeply regret, as does my colleague, this senator, our colleagues in the House from Illinois, the improprieties that have taken place. But I would want to strenuously argue that the law is taking its course. By and large, those people have been found. They have been brought to justice, and the system has worked, just as it works against members of the Congress, or bankers, or businessmen, or labor union leaders, or others who do inappropriate things in the performance of their functions in whatever capacity they perform. So I appreciate my colleagues listening to me today, and to my friend and colleague from my state, Paul Simon, and I would suggest that in the final analysis, this is an international marketplace. We compete not just with New York, Kansas City, and the coast, but we compete essentially with London, Tokyo, Singapore, and the whole world. And if we take steps that are injurious to our market, I think in the long term it will be a grievous error. And so I would urge you to be careful in what you do, and to remember that the free marketplace by and large works well, and that a reauthorization of the CFTC with a relatively clean bill ought to be, I think, the standard that the committee ought to seek to ultimately achieve. And I thank my colleagues, and in the absence of the chair, whoever be jurisdictional, I ask leave to place this in the record.
Without objection, we'll accept your statement as if given in full, and we appreciate, Senator Dixon, very much your being here. And I think I can speak on behalf of the chairman to say that this committee knows it has a responsibility to react. The events that have occurred are of significant seriousness, that we've got an obligation to respond and react to assure those who are dependent on these markets that they are fair and effective and honest. At the same time, we understand we can't overreact and regulate these markets out of existence or push them offshore, and that we're sensitive to the tension that exists here between responding to assure confidence by consumers, and on the other hand, not to overreact in a way that would injure these markets and force them overseas.
I thank my good friend from North Dakota for that comment. I'm entirely comfortable with his common sense approach to everything, and know he'll take that approach to this. Mr. Chairman, in your absence, I ask the leave of the distinguished chairman of this committee to place a very moving statement in the record. May I have that leave?
And you know that the chairman can hardly wait for the recess to be able to read it.
I know that. I expect to see you under some tree out in the yard, slowly reading this statement
in the rain.
At your leisure.
In the rain. Of course I will. You have my word on it. Actually, all joking aside, I will. This is a serious matter. And both you and Senator Simon have talked to me before about it. I would just remind everybody that we either react in the Congress and react in a way that the American public can have confidence in what we've done and have confidence because it's substantive what we've done, or we can look for a political way to avoid the issues that have been raised by the sting operations and others. If we do the latter, we do the commodities, if we do the various exchanges, no good whatsoever. Because if we look for a political fix, if we look for a way not to face up to the tough questions, then the American public will lose confidence in these markets. The integrity will be shattered, rightly or wrongly, and we do them no good, and we will end up losing these markets overseas. It's a unique part of the American enterprise system, and one that I am dedicated to keep. I want us to have these markets here. I think they're extremely important to our country, extremely important to the orderly flow of everything from commodities to money. But they exist only if they have integrity. And that's really going to be the chore of all of us, Republicans, Democrats, everybody else involved in this. And that's what this committee is.